Judge Larson is running for state Supreme Court. In fact, he's one of the two candidates who made it past the primary election. And he put out a lengthy statement about all of this. I want to read just a part of it for you because I think he expresses something that a lot of us are concerned about. He said, "This is just the beginning. Win, lose, or draw, the people who do not agree with the outcome of the election in November will turn to the courts in the hope that the courts will override and nullify the outcome in some way that undermines the vote of the people. This should concern you, regardless of whether you support or oppose these initiatives. Keep in mind that if you allow interference this time because you are against the initiatives, then the same precedent will be used to prevent you from voting on initiatives you agree with in the future." And I echo those sentiments wholeheartedly. And I think there's a lot of people who, one, weaponize the judiciary to their benefit, or attempt to at least. And then people who don't trust the judiciary to make decisions that aren't politically motivated. And so how can we change that? Where do we go from here? So Judge Dave Larson was nice enough to join us on the show today. Judge Dave Larson, welcome back to Undivided.
Thank you for having me. I think it's a pleasure.
Yeah, first, let me congratulate you on making it through the primary election. How are you feeling heading toward the general?
Oh, very optimistic. I think the fact that I'm the only judge, I think that's something that's very important. I mean, the idea of being a trial judge, when you're judging what trial judges do, being on the Supreme Court is absolutely essential that you have that trial judge experience, because you have no frame of reference when you're looking at the decisions judges are making, and then you're put in the position of second guessing them. And if you don't understand what goes into it, it makes it a lot more difficult. So I'm pleased the voters recognize that.
Yeah. And I don't want to put you on the spot, but I'm going to. I've only endorsed one candidate in this election cycle, and that really had been my plan. I've endorsed Dave Reichert in the governor's race, but I would like to make it a second one, and I would like to offer you, if you want to accept it, you don't have to decide now, but my endorsement in this race, because I think it's one of the most critical races we're facing.
I would very much appreciate that. The endorsements haven't been as important to me because I'm trying to talk about the issues. And yeah. When endorsements become the centerpiece, people want to then attribute views to you as a judge because that person endorsed you. I'm very stubborn about being a judge. And so just because somebody endorses me doesn't mean I adopt their views. Yeah. I got the president of the NAACP of Washington, Alaska, and Oregon endorsing me. I have law enforcement endorsing me. So the idea that some people take the endorsements and try to superimpose the views of that person onto the candidate. And in judicial races, that has to be very important, that it's understood that an endorsement doesn't mean I adopt the views. Yeah. But the endorsement is very important because it says this is somebody that I think would be a good judge. And so in that regard, I'm thrilled that you endorsed me.
Well, and I think what's going on for me here is we can't have ideologues as judges. Like, that's my big thing. And that's always what I've been about is, really in political office in general, just sort of looking at the extremes on both sides and saying that's just not what serves people. And in our conversations, you're not an ideologically driven person. And if you are, then you hide it pretty well and you're able to just do your job as a judge well. And you said something in a recent statement that really spoke to me. You said you want to get the judiciary back to what it's supposed to be, boring and dependable. Like, that's what I want out of my judges, boring and dependable and not deciding issues based on politics.
And that's exactly it. I mean, the judiciary should be that thing you can, where you can take a sigh, knowing that if it's going to go there, it's going to be a fair result. And right now, I don't know that people feel that way about the judiciary in general, that there's a fear that it's politically driven. And so therefore, if a political issue makes it to the court, if you're not on the side of the court's in power, or the court in power, you're thinking you're not going to get a fair shake out of the gate. Yeah. And that's just not acceptable.
No. So let me, let's touch on the issue at hand. You put out a statement after this news that, the state Supreme Court on Friday had thankfully, in my opinion, decided to reject a lawsuit that sought to undermine the initiatives. Why did you feel like it was important to put out a statement offering your thoughts on it?
Well, first of all, the notion that due process and fairness is essential to justice, and the idea that somebody that's really involved in litigation wasn't notified is a sign that we've maybe lost some love for that, and that needs to be essential to our existence, the due process and fairness. the idea that you notified somebody else, it's like telling your milkman you get telling the milkman you got sued. It's not the same thing. You have to. It's a respect issue, and you can tell the difference between when you're acting on principle and when you're acting on partisanship. Where if you think the rules should apply equally to both sides, you're acting on principle. So if it was the other way around, and either a person of the opposite political party was in office and didn't notify somebody with an opposing view of if that's wrong, it's wrong in both cases. So here, partisanship applies when it's right if you're the one doing it, and it's wrong if you're the one on the receiving end. And that's where I'd like to get it to focus. And also the idea that this affects everybody, not just the people that are in favor of the initiative. It affects the whole process. It affects the ability of somebody to make a decision if they're no now to change it to yes, or if they're yes now to change it to no after they've heard the arguments and gone through the process. It's an essential part of our Constitution to have initiatives. We're relatively unique in that way. And it's if they don't want initiatives, get rid of it. But as long as it's there, you have to enforce it the way it is.
Yeah, and I know. So if people aren't familiar, it's different. It's difficult and different to run a campaign like you're running for a state Supreme Court, because you can't comment on existing cases or even cases that might come up in the future. It's my understanding. So there's some restrictions you have. But that being said. Yes. I think I'm just concerned overall about the amount of lawfare I see related to initiatives. We have this constitutional right as the people to run initiatives and referendums, and there's constantly these legal efforts to undermine them or to keep them off the ballot or to reverse them after voters have already passed them. Why are we in this place? What's going on that there's so many legal attacks on initiatives of the people?
Well, judiciaries over the past few decades has been politicized, has been hijacked, in the sense that when you hear of an opinion in the federal courts, you got to know who the president was that appointed them, because it's got to be political, right? So essentially, and then getting people on the court, they're going to decide the cases politically the way you want them to. That becomes the next pressure after you think the court's a conduit for political relief. Then you want the judges on that are going to side with you politically instead of the ones that are going to decide the cases based on the law and the Constitution. So we've gotten ourselves here because as constituencies of the judiciary, we've expected in a lot of ways in the election process at this level in Washington State, and the selection process at the federal level in the confirmation process, we have a push to make sure the politically favorable person is in the judiciary, which gives the impression that person will then favor you and politically, and it shouldn't be that way. It has to change. We have to hit the reset button and say no. This is about people that are willing to check their opinions at the door and decide cases on the law and the Constitution and let the political process work its way through.
Yeah, and I just want to end with this because it's something that's playing out on social media right now. And I'm not a legal expert. I don't pretend to be a legal expert, but you've been practicing law for 40 years in the field. So help me understand, you mentioned it off the beginning. And I've said, I think it just strikes me that, that we could get to 2 hours before a state Supreme Court decision on something this consequential, and the backer of the initiatives doesn't even know about it. It just strikes me as, how is that even possible? In your mind, are you willing to say whose obligation it was or responsibility it was to notify them?
Usually, I'm assuming there's a custom involved, and usually if somebody, it would be in this case because again, I don't know if there's anything clear legal answer. Mm-hmm. It's really a moral and fairness issue. And so the question is the Secretary of State, because the person that filed the initiative with them, the Secretary of State would know, the lawyer representing the Secretary of State. But I would think it has to do with fundamental fairness and respect and dignity to be able to give somebody that's taken the time to gather signatures throughout the state, and this would apply whether it's Democrat or Republican-based initiative, to give them the respect of knowing, hey, there's litigation. And by the way, this litigation has been pending since January.
Yeah. And so it is a surprise to you. It's not just me thinking that sounds highly unusual. That does sound odd to you as well.
Yeah, it's almost like I mean, it is odd. There's also rules that may apply with whether a party's a necessary party and things of that nature. Whether you get into the murky area of that and legally, then but it gives somebody a chance to intervene too, because there's rules that allow intervention in litigation, and so the court rules allow for the interested parties to impose themselves into litigation too. So that and then also the legal binding effect sometimes is necessary to have that interested party involved to apply other rules, such as collateral estoppel, which is a rule that prevents relitigation of the same issues.
Yeah.
So there's all kinds of reasons why you'd want that interested party to know, legally and morally. But as far as a specific duty to notify, I don't know if there's a legal duty, but it certainly falls in the category of what's fair and unfair.
Yeah, and let me just end with this more broadly, because people are they don't trust our courts, I guess, to make decisions that aren't political. The lawfare issue that's bandied about. How do you think we restore trust in our judicial system, where a case like this, can go before a court or be adjudicated, and people don't automatically assume that the outcome is just not going to be fair?
It's heartbreaking for me, since I care so much about what I do and love so much what I do, to have people not feel confidence in what we do. It's earned, and we haven't earned it, and we need to get back to earning it. And that's where we've had that discussion between power and responsibility and the difference. We need to have the judiciary adopt an ethic of responsibility instead of an ethic of power, so that we fulfill our duty to the people of the state and across the nation in all judicial races, in all judicial areas, to live up to that creed of being that we're supposed to be, like I said before, a beacon for decency, a beacon for how you're supposed to resolve things. We should not have ourselves up to our elbows in politics.